My name is Noel Goddard. I'm from Qunnect. Spoke at one of these earlier quantum marketplace events. Our company innovates devices to transform the existing telecom infrastructure into scalable quantum networks. And the device suite, as you see on the left there, is a set of devices which, because we've been through the IP process on this, like many of the talks which you heard here today, each one of them is a collection of patents that have to do with either features or the devices themselves. On the right-hand side, we're starting to build a test bed in New York, which again will end up more than likely producing more IP. And we know as we're starting to walk down this road that compared to the earlier days when the company was first starting, the best way you can deal with anything in intellectual property is to get out in front of it. So the moment that you have an idea, you should really be discussing with your intellectual property lawyers, and you should have intellectual property lawyers who understand quantum so that they can help you best strategically place your claims and your early filings into the patent offices. So something I really wanted to touch on is closer to what Kanaya spoke about at the beginning of the session today. And that's the fact that a lot of these things you think may not affect you, like export or CFIUS because you're not doing this yet, can actually affect you, and you might already be violating things that you didn't realize you were violating. So for instance, I put a few examples here. When you start to craft an R&D business strategy, you're choosing to create a set of products. You may or may not be aware that some of those are already covered by the existing export control guidelines. And I put an example here. So this comes from some of the commerce classification language. This quote, designed or modified to use or perform quantum cryptography, is a very broad bucket. So my company does quantum communications. Is that the same as quantum cryptography? Well, you should know if you're going to be producing these types of instruments because you want to be very careful that you understand the controls which are put in place. And again, there are experts in this at many of the full service law firms that have export control and CFIUS counsel. Similarly, the commerce classification rules are a living thing, so they can broaden over time. And what could actually happen is that something that is not controlled now could actually fall under some control language, even though it's meant to be under dual use. And a great example of that, which everyone was highlighting a few years ago, is a supplement that came out from those offices, actually controlling cryogenic refrigeration technologies. So again, it's something that you may not think of as naturally something that should be controlled, but it is something that falls under these laws, and you need to know about them in terms of your company's strategic direction. Similarly, if you are a young company, the chances that you're hiring people straight out of academia is high in the quantum space. And we all know that we have a very international workforce in the United States, which are getting degrees and doing postdocs here. And some of you may or may not be aware that when you start to accept different types of federal grant funding, all of those pages of contracts that you did not read when you were a graduate student actually come into play when you are now trying to build a workforce within your own company. And the reason for that goes back to what they were saying in the first talk today. Export is a broader defined term than simply exporting a device. It's exporting knowledge. So there are federal grants and contracts which actually have restrictive language about the persons which can participate in those grants. And some of those may be things that you take for granted, like an STTR from the Air Force. Well, read the fine print because it's important, but for the small business, how do you get around things like this? Well, the first thing you can do is you can create a technology control plan. Again, I advise that you work with counsel on this. And it actually allows you to isolate the project and the team members that are doing the project away from the larger group, which is at your company. And sometimes this causes you to actually have to rent a secondary space, but is something which is acceptable to some of those contracts. Secondly, you can actually work with an export control lawyer to classify the technology you're working on. And if it falls under a control category, there are exceptions called license exceptions for export, which you may qualify for so that you can actually work on these technologies with your international staff. Finally, something that some of you may be running into is that the foreign investors sometimes are a little bit more quantum friendly than the US investors. If that's the case, your foreign investors could actually trigger a CFIUS process, depending on the amount of their ownership. Or, as was mentioned also in the first talk today, there are other things that fall under the category of control, like having a board seat, which can also put you in the position of needing to actually file for CFIUS disclosures. Again, there are councils that specialize in this, but as we learned today, that's something which is like a 90-day plus process. So you just need to be aware of these things when you have a very small company. Qunnect, has been really actively pushing forward in the ecosystem since late 2019. And we've touched on every single one of the topics that you see here, as well as the intellectual property stuff that we heard about today.